My name is Raleigh Maxwell,
I'm Josh Clark.
and welcome to Topic Knowledge, a policy debate central production.
Today we're fortunate to be joined by Wayne Tang, patent lawyer for Nixon Peabody. Did I say that right, Wayne?
Yeah, no, that's correct.
And also the debate coach at Northside College Prep, and alongside and one of my good friends in the community. Thank you for joining us here today to talk about the new resolution.
Yeah, yeah. So, yeah, no, I was like shocked that they picked this one. It is, as somebody pointed out, it is not something that we've seen either at the college or the high school level. And it is a pretty specialized field. It's a lot like debate. It's really, really important for our economy and our legal system, but nobody really pays attention to it, or really at the national level really cares that much in Congress, except for a few very specialized experts. So it is a good chance, I think, for high school students to delve into, basically see how a pretty complex system works. That's very important, but doesn't get very much publicity.
That's great. How long have you been working in this legal industry?
Yeah, so I did the classic. I was a high school debater. Fun fact, I attended the Southern Bell Forum 2. I'm not going to talk about what number it is on now, but that was in high school. So, being Asian, my parents gave me the awesome career choices of being a doctor or an engineer. And so I took engineering because I threw up in biology class in high school. So like I became I got an electrical engineering degree, but because of my background in debate, I knew I wanted to go to law school. And so I ended up going to Michigan Law School, and then moved to Chicago, got a job at a patent firm. And so I've been practicing patent law for over 25 years now. Um, and so I have a decent knowledge. During that time, I coached a lot, and I've got sort of both perspectives. I know the industry pretty well, I think, by this time, and I know the debate industry very well.
What's like a cool something that you have worked with, like of a product or a trademark or a patent or something?
Yeah, so basically when like unfortunately this is no longer, they don't really do a lot of development anymore, but I used to do slot machine patents, and I did a lot of slot machine patents. So I know a lot about slot machines. I know how they work, I know the security protocols, I know the electronics. What I don't know, however, is how to play one. So one time I got free credits on a slot machine, and I knew exactly what would happen when you hit ticket, and like, how the random number generator worked. What I didn't know is how to start the machine. So I had to ask a very kind little old lady, hey, I have this ticket. Can you tell me how to play this thing? I can tell you how to design it. I can't tell you how to play it. So yeah, I had lots of good technical knowledge, no practical knowledge.
Okay. Well, we're excited to talk to you today about the resolution.
Yep.
I think Raleigh has our first question.
Okay.
So if you could kind of introduce the resolution, what each of the words mean, what the topic might look like, that would be great.
Yeah, sure. So the resolution this year is sort of your standard resolution. So it's the United States federal government. And so the first thing you have to recognize is that it is all federal. So unlike a lot of so-called domestic topics, there is no state's counterplan because unlike other federal powers, this one is specifically in Article 1 of the Constitution, specifically Article 1, Section 8, which gives Congress the power to set up essentially the patent and copyright system. And so the founding fathers did a pretty good job on this one. They actually, specifically put in a specific description of both copyright and patent if you read it carefully. So the second sort of part of it, which is very important, is strengthening. And so strengthening protection is basically, I think, can be divided into two sort of mechanisms that affirmers can do. So the first part is making it easier to obtain intellectual property protection. And so intellectual property protection is broken down in the resolution to three sort of things: patent, trademark, and copyright. And I'll talk about each one of them, what they are. The other way to make it to strengthen protection is to make it easier to enforce those things. And by enforce, that means if you get the property right, then the way that you enforce it is if somebody is infringing your property, in other words, trespassing on your property. If you think about it as a piece of land, if somebody's on your property, you can sue and get the legal system to basically stop them from trespassing. In which case, in the case of intellectual property, it's either giving you damages and or making you stop the infringing practice. The term intellectual property is a very specific term of art. So intellectual property rights, I think the key is property, and it's based off of a theory of property which has economic justification. So the reason why property, and this is a Western concept, by the way, there are lots of societies historically that haven't had a concept of property. But the way it's spun in sort of Western systems is that it is economic assumption that property conserves resources. So in other words, if I have a common pool of resources, the idea is everybody has an incentive to go in and exploit the resources immediately, because if they don't, somebody else will. Okay, whereas if I make it owned by somebody, then they have incentives to preserve that resource. And so the concept of property for UK debaters is something that is immediately critiquable about the resolution. The final part is understanding what copyrights, patents, and trademarks are. And I think that in increasing order of importance, trademarks are basically a symbol or a mark or a word representation of a product. Okay, so things like Coca-Cola are famous trademarks. Okay, unfortunately, based off of the research I've done, which is very minimal, I don't think they're going to be a big part of the resolution, simply because there's not a big impact you can trace to trademarks. Well, however, I'm sure some industrious debater will find some link to trademarks and hedge, and they'll run an advantage. But as far as I can tell, there really isn't one. The second sort of branch of intellectual property is copyright. What copyright is it protects the expression of an idea. And so those would be things like books, articles, movies, music, okay, and other specialized things. And copyright is probably going to be a subset, and there might be some advantages off of it, specifically in terms of relatively discrete items. So, for example, it's very important for the music and entertainment industry in general, because believe it or not, when you put out a musical album, you really don't want people to replicate it infinitely without paying you. And that's the same for movies and things like that. The problem is, again, I haven't found the hedge card yet that says that Taylor Swift is critical to U.S. military readiness. So I'm not 100% sure, even though the economic impact is big, I'm not 100% sure that's going to be a big debate advantage. However, it does have implications. Yeah.
Just out of curiosity, is the copyright what you're allotted for 75 years, or is it kind of?
Actually, it's 95 years, because the Steamboat Willie copyright was going to expire in the early 2000s, and Disney did what every good corporation did. They went to Congress and asked for an extension, and they got it. So it expired a few months ago, but. So yeah, as Rhonda,
Steamboat Willie is now free domain.
Steamboat Willie is in public domain. However, the other Mickey Mouse copyrights are not, because they're still within that year. So, as Ron DeSantis can tell you, don't mess with the mouse, because they'll go to Congress on you. The other implication for perhaps for copyright is traditionally it's been used to exploit artists. Okay, and so there could be critique implications for that. Also, it has implications for artificial intelligence. Because especially with LLMs, large language models, they rely on essentially vacuuming the entire internet to essentially learn. And the question is whether that vacuuming the internet is a violation of copyright. And so you could have implications on AI for copyright. So the final,
I was going to say, I think that's the Emory's F for their for their introduction packet is that app.
Oh, okay. Yeah, I haven't seen. I didn't know they already put out evidence. I'll have to take a look at it and put it in our Dropbox. Like all like, you know, we are like a less efficient LLM. We vacuum all speech documents, but the only goal I have as a coach, by the way, is to get speech documents in after rounds. I mean, it's not winning the TOC, it's not winning trophies. It's if my teams ever put the speech documents in the Dropbox after the stupid round, as opposed to, hey, like you debated this team a month ago, and yeah, we don't have the speech documents. Where are they? But yeah, so I'll have to take
I know that fight too. Definitely happens on our team too.
But anyway, so the third piece of intellectual property, which is in the topic, which I think will probably be about 90% of the apps, is the patent system. And so patents are essentially a property right that protects ideas. Okay, and so the deal is that it gives you a limited monopoly to exclude others from practicing the invention. So the economic rationale for a patent is that it gives you an economic incentive to develop technology, because if you're a first mover, you get functionally a monopoly over it. And so that incentivizes you to develop technology. And the deal is that after that time, you have to dedicate it to the public. So after the patent term, that technology is useful for, or can be used by anybody. And so there is also going to be a big debate on whether that's actually true. And there is a lot of literature on reasons why patents help innovation. There is a lot of literature on why they don't help innovation. And so I think that it would behoove all debaters to understand both sides of that debate, because that's going to be a big debate, whether you run as a case turn or disadvantage. Assuming that most apps are going to be patent oriented, which I think they will. So
And
those
then-
are sort of that's sort of an overview of the res.
And then for my research, it seems to be like trade secrets is kind of like the fourth horseman of like IP with trademarks, copyright, and patents. So one, like what are trade secrets? And two, how do you think its exclusion will kind of impact the topic?
Sure. So trade secrets are traditionally intellectual properties, all four branches. Trade secrets were probably excluded because, like, you know, they didn't want 60 more apps. I don't know. But trade secrets have traditionally been state law. So all the states have specific trade secret statutes. Ironically, there's something called the Uniform Trade Secret Acts that most states model their trade secret law off of. So a lot of trade secret law in states is relatively uniform, and so that's a good argument for the 50 state fiat, obscure argument for why 50 state fiat legit. The federal government, however, did pass something called the Defend Trade Secrets Act, DTSA, a number of years ago. So it does work on the federal level as well. So what a trade secret is literally that, is you keep your technological development secret from people. And that's very effective for things like chemical formulas, which are really hard to figure out, and some in guesses. Computer firmware, for example, is really difficult to ascertain, because if you have an electron microscope, you might be able to figure out what 1 million transistors do, but you're guessing. Okay, and so trade secrets are not effective, however, because they don't prevent legitimate ways of competing. So, for example, if you have this cool piece of software, it is perfectly legitimate for you to buy that software and then, you know, make a list of what it does, and then go tell my software engineers to go code something that does exactly the same thing. That's legitimate. That's not a violation of trade secret. What is illegitimate, however, is, let's say you work for that company and I entice you to come over to my company and tell you to, like, have a flash drive and download the entire software and give it to me. Okay, and so trade secrets don't prevent legitimate copying, which patents do prevent. So if you were to do that and I had a patent on it, I can then sue you because you're using my idea. Trade secrets, if I figure out the idea myself, there's nothing that prevents me from going out and having a competitive product. And so trade secrets are very useful in certain aspects. They're not so useful in other aspects. And so they can be an alternative, and there are decent arguments, but they're very specific because they break down if the trade secret protection is not effective. The other thing is that patents are written down. So in theory, you know what the property is. Trade secrets, you don't know how effective the trade secret is until you get to court. Which again is good for me, because they pay me for that kind of thing.
So getting through kind of the definitions of the resolution, one of the things that I learned from your lecture, topic lecture that you gave to the GBS folks, was just how much debate there's going to be for the branches of government this year, as well as different governmental agencies, different courts. Would you mind giving us a rundown for the
Sure.
topic on, all the government actors that'll be kind of talked about this year?
Yeah, so this is this part of the topic is great for those of you like it hiding a spec because yeah, it's sort of relevant this year. The way intellectual property law works is, again, it is based off the Constitution, which is the fundamental legal document. Unfortunately, since the Constitution is sort of short, Congress needs to make laws. So the role of Congress is to essentially have patent statutes, which is 35 USC 101, and there's probably about 30 or 40 sections that govern patent law. There's probably 4 or 5 very relevant ones that deal with the conditions on obtaining a patent. So again, those laws determine the strength of intellectual property protection. And so the role of Congress is that congressional plans could amend those statutes and make it easier to get patents or easier to enforce patents. So that's the role of Congress. They make law. Okay. The problem is that Congress basically doesn't have enough time to study the laws in painstaking detail. They do a not a bad job from a general policy level, but in order to interpret things like, for example, the word non-obvious is in section 103, so patents have to be non-obvious. Well, the problem is it's really hard to figure out what non-obvious means. And so if you put two things together, is that obvious? But well, the problem is all inventions and pretty much anything creative, quote unquote, is actually just a combination of known things. And so if you think that it's pretty easy to put these 3 things together, then you don't get a patent. But if you think if the standard's a lot harder, then you get more patents. And so, for example, the Supreme Court has opined on what obviousness means, or it put out a bunch of tests in a case called KSR that's about 30 years old. Basically, the Supreme Court doesn't do us many favors because even their sort of clarification of these things is not that clear. Another significant case is patent eligibility. So you can't get a patent on everything. So, for example, you can't patent physical laws, you can't patent math, you can't patent human beings, things like that. And so there's a separate section of things that you can and cannot patent. Well, as Raleigh has pointed out in his awesome question of, hey, this Alice test. So Alice was a case that was decided in 2014 by the Supreme Court that tried to clarify what is eligible for patentability. So what happened is that basically there's these things called computers that were invented. Terrible idea. Now apparently they're a big part of our economy. And basically software arguably is an algorithm, which means you can't patent it. But the problem is that computer software is an insanely big part of our economy. And so one part of the problem is this Alice decision is being used to prevent software-based inventions from being patented. That's the long and short of it. Obviously, there's ways around it, and that's why they pay me. They actually pay me as opposed to my debate coaching job to try to figure out ways around it. But this is a big issue that is making its way through the patent office and the courts, or it has been since the Alice decision. So those are examples of how the Supreme Court, in their interpretation of statutes, can affect protection of intellectual property. So the final branch is the executive branch. And the 2 main agencies that are relevant are the Library of Congress, which runs the Copyright Office. The Copyright Office grants copyrights, and the U.S. Patent Office, which is part of the Department of Commerce. The Patent Office is basically their job is to examine patents through a process called patent prosecution. And so essentially that is a negotiation of how broad your rights are. So the difference between physical property and intellectual property is physical property is something that is relatively easy to find because it's physical. So if you have a piece of land, it's really easy to figure out where your land begins and ends. So, for example, if Raleigh sets up a tent on my land, I can pretty much figure out whether he's trespassing or not because I have a property line. Intellectual property is described by words. And so essentially intellectual property, since the property is defined by words, you're not 100% sure whether somebody's trespassing. It really depends on the interpretation. So it's like a big T debate. Okay, in fact, that's what a lot of patent cases are. It's a gigantic T debate, assuming you had infinite prep time, infinite resources, infinite speech documents, and $1 billion was at stake. And so like people, because as we know as debaters, the T debate is not about the violation, it's about the interpretation. If you get the right interpretation, then you win the violation. And so a lot of patent cases are about claim interpretation, which is the legal definition of a property. So the patent office basically grants patents according to the standards set by the statute, the courts, and their own internal standards, which are rules that they put out. Okay, and this is where the notice and comment process, which hopefully most experienced debaters understand, although based off of some of the rounds I've seen, they don't get it. But things like that are how the agency makes rules. Now, there's something called Chevron, which is deference to agencies. And if you've ever read some of the awesome right-wing commentary on how the unelected deep state is making rules, this is a good topic to understand why you should probably have the unregulated, unelected deep state make rules, because they're experts in this area. And as good as Congress is at defining statutes and as good as the courts are, and by the way, they're not good at either of those, okay, you need experts to tell you what the standards are. So for example, this obviousness standard, there are literally 200 pages in the manual that patent examiners use to determine obviousness that give you very specific criteria, and even those are vague. And by the way, all those are Fs. You can change all that stuff.
Yeah, I was gonna say, it sounds like this agency their rulemaking will be like a pretty normal actor on the topic.
Oh, absolutely. Yeah. Yeah. So for example, the problem is that the rulemaking is probably more specific than what the courts do, because they have to deal with this on a day-to-day. The courts only have to deal with it when you get litigation. And so there is a disconnect between certain areas. So for example, the patent eligibility, which I was talking about specifically in terms of software, the patent office, it's a lot easier to get patents that are related to software through the patent office. The problem is that once they get to the courts have taken a very hard line in terms of enforcing software-related patents. In fact, like I think the number is the last 3 years, there's been maybe 80 or 90 cases decided by the Federal Circuit Court of Appeals, and the patents are survived in 4 of them. And so, so your chances of getting, once you get to the appeals level. Oh, did I mention there's a special appeals court that handles all patent appeals? Yeah, so there's a special circuit court called the Federal Circuit Court of Appeals. So all patent appeals in federal district courts go to the specialized court. And the reason they set it up in 1981 is to get consistent decisions through patents, because they thought that it was important to get consistency. The problem is that the judges on the court have very, very divergent views on certain issues. And depending which panel you will get diametrically opposite decisions depending on which panel you get on very similar fact patterns. And then obviously, luckily in the debate world, we can fiat the Supreme Court. The Supreme Court is not a fan of intellectual property decisions, by the way. They only take about one every 3 years. And given, and here's how important they think it is. Thomas has written most of them. In fact, he wrote the last one, which just came out yesterday on trademark. So yeah, they're not fans.
Okay. So they stay away, and Thomas writes the. Okay.
Right. But the good news is, well, the not so good news on the negative is really there's probably not going to be too many political court capital disads, because again, they don't care. And really, if you look at most intellectual property decisions made by the Supreme Court, they generally 9-0. So they'll make a decision, and it's not something like abortion or something where they have an ideological stake in it. It is literally, yeah, this is how it would be. Let's issue something vague that we can fight about or the lawyers can fight about for the next 15 years. Because
You mentioned
yeah,
you mentioned the Court of Appeals for patents specifically. So that's distinct from like specialized courts for patents. Like I think Europe has those, correct? Or at least some
correct.
nations in Europe.
Yeah,
So would
so
an affirmative could hypothetically create like a whole system just for patent adjudication?
yeah, it might not be a bad idea. So the way patent decisions are made is you get your choice of a jury or a judge. Okay, federal judges, in general, are relatively smart people because they have to go through the Senate, and even Trump didn't appoint total idiots for the federal judgeship. So they're generally pretty smart people. The problem is that they're not technical experts and they don't see patent cases day to day. Although there are certain districts that have gone into cottage industry of doing patent lawsuits, and so some of those judges are a little bit more expert. So if you have the judge make the decision, you know they'll try hard, but there's no guarantee they're going to decide based off of either the law or they'll understand the technology. It's really sort of hard sometimes. So some patents are pretty simple. Other patents, like on microprocessors, for example, are not that easy to. And especially when the judge has like literally 100 cases on their docket, they're not going to sit there and spend their time learning microprocessors. I mean, it only took me 2 years to, take all 6 courses and understand like the basics about it 30 years ago. I'm sure it's a lot less complex now, right? Okay. Your other alternative to have a jury do it. You always have the option of getting a jury. Okay, you just got to mark the little box. By the way, those of you aspiring attorneys, you should probably advise Trump's attorneys to do that if they want a jury trial, because they failed to mark the little box, and that's why he didn't get a jury in the Carroll case. But in any case, juries, on the other hand, definitely are not technical experts. They're not legal experts, and so they're going to go with their gut. So like, basically, if you want to, if you want to use trial strategy, it's probably a good idea to litigate in your hometown where your factory is, and you can make arguments like, hey, this factory that employs 25,000 people. I'm sure some of you know some people who work for company X. And by the way, if we lose to these dirty, rotten Chinese infringers, yeah, they're all going to be out of work. So I'll think about that. Okay, and so litigation has a lot of debate strategies. But like, in debate, you don't get to pick your judges. In patent law, sometimes you do. So what Europe does is they actually have specialized patent courts that make these decisions. They actually know something about the law, and they're actually also technology experts. So there has been a decent amount of writing that thinks that this might not be a bad idea, especially since the economic stakes are so high. And by the way, I'm sorry. So if you appeal from the first level court, then you go to what's called the Court of Appeals for Federal Circuits. Those judges are specialists in patent law. They're not necessarily technological experts. But like I said, the problem is they have divergent views on what the law should be. And that is creating all kinds of chaos, especially in software.
So I was going to ask before we move on to some of the specific questions. I think you mentioned you thought that the patent portion of the topic would be something like 90% or of the AFs. Could you elaborate on that?
Yeah, sure. Debaters, I've only been in debate for a number of decades. Like, they like big impacts. And so, like, the trademark impact of Coca-Cola, like, oh my God, like, somebody's like selling artificial sugar water, and like, people won't figure out it's Coke or something like that. Yeah, there's not really impacts to that. There's like, as bad as it is, copyright holders screwing over artists, there's no real impacts to that. Patents, on the other hand, since they deal with technology and the economy, have gigantic impacts. And so you can not only access the economic impacts, you can access pretty much any technological impact for any tech file that you can find over the last, say, when was electronic debate started? Like 2008 or something like that. So you can go through the back files. And I have a running slide of list of technologies, just stuff I remember from files. And I'm sure, Josh, you have that too, because you've been around as much as I have. So, if you want to have your blockchain
old, Wayne.
yeah,
Don't
you just
call me
have
old.
I saw you in a video in 2004.
Yeah, I'm old.
It's a pretty good one. Yeah. You looked a lot
Think
younger back
so.
then when you were debating in college. But yeah, so if you want like your blockchain advantage, all you got to do is resurrect the cards from 2 years ago. If you want your quantum computing app, you just need to resurrect the cards from the NATO topic, and I believe it was like a topic maybe 4 or 5 years ago. If you wanted your climate like technology, like there's tons of cards on that. You can pick literally nanotechnology, Internet of Things. There are technologies, pharma, and I'm sure I'm forgetting some, but basically you are good to go once you find your internal link to why. So there's two types of internal links. So there's generic internal link that you can find pretty much in any solvency article saying patents are good for technology. They'll probably list some of the technologies. There will be a decent number of good internal links that say specifically why patents are key to nanotechnology development or semiconductors or whatever it is. And so, I think that the AF can run all the linked advantages to that. So not only the technology in terms of the technology specifically, but it's key to military readiness. It's key to space exploration, key to climate. And so, yeah.
And then you mentioned at the beginning that protection could kind of either make it easier to someone to obtain like a patent or increase enforcement of the patent. Could you elaborate on kind of what you meant by that? Like, could an app feasibly just make it like the process of applying for a patent through the patent office easier, and that technically be like a strengthened protection?
Yeah. Yeah, I think that's debatable. So one thing about the patent, a couple things that are interesting about the patent office. The first thing is it's the only one of the few federal government agencies that actually makes money, and so they charge fees for every time you've applied for a patent. Well, I think Congress has stopped this practice, but basically anytime they made money, Congress would swoop in and take it. So they got a lot of things they got to pay for. A lot of the patent office right now, basically there's a backlog in certain areas like software, for example, or biotechnology, because a lot of people are applying for patents. So it's taking longer to get those patents. So arguably topical would be things like hiring more examiners, increasing examiner salaries. Okay, things like that would reform the patent office internally. I think that those are gray areas in terms of strengthening technology, strengthening intellectual property protection. But I don't think you need to go there. I think there's plenty of AFs that straight down the middle would, if you loosen the criteria for getting a patent, for example, by definition, more patents will be granted. And so there's a lot of things you can do on that. But if you want to get into the more adventurous part of the topicality debate, I think that there's lots of proposals that are out there in terms of patent office reform that streamline these things. By the way, there is also internal procedures to fast track certain patents. And so you can model certain AFs off of those. If you think a certain technology is important, you can encourage them to move those types of patent applications to the front of the line. And so that's the obtaining patents part of it. The enforcement part of it is court litigation. And so patent litigation is generally relatively high stakes litigation, because patent litigation is just insanely expensive. And so unless you're selling a lot of it or a competitor selling a lot of it, you're generally not going to court because it's too much. Okay, which means that the cases that go to court are gigantic. And so there are a lot of procedures that are designed to try to streamline those things, or could be designed to streamline litigation. And by the way, you can challenge patents based off of they shouldn't have been granted because somebody has already done them, or they are under ineligible subject matter. So by changing those laws, you both increase the number of patents that are granted, and you also make it easier to enforce, or vice versa.
So courts have kind of the authority to like reverse a patent office decision of like granting a
absolutely.
patent? Okay.
Yeah, but by the way, the patent office can as well. So there's something called an IPR, an inter partes procedure, or inter partes. Um, and this procedure allows any party to go into the patent office and say, this patent was granted. I don't think it should have been granted. And there's a separate legal procedure for that. And so you can have a patent go on parallel tracks. For example, I could sue somebody on this patent. And the first thing the defendant generally does is they go to the patent office and they go, okay, we're going to challenge this patent in the patent office. And by the way, judge, please hold off the litigation. The patent office will decide, and therefore they can delay it for up to about 18 months, which is how much time it takes. And so there can be different things that go on different tracks.
And enforcement is entirely predicated on people like bringing suits. Like the patent office won't go out and.
Yeah, the patent office's
Okay.
function is to grant patents. The patent office's function is not to enforce patents. Okay, and so yeah, so if you think somebody's infringing your patent, you have to sue them in federal district court.
And then I did have one question about patent trolls, which I've seen in the literature a little bit.
Yep.
So one, like, what are patent trolls? How are they legal? And two, like, where do you think they might pop up on the topic?
Yeah, all over the place. In the answer to your last question, all over the place, because it is a big problem. So what a patent troll is keep in mind, patents are pieces of property. And so if they are pieces of property that have negative rights. So in other words, I can exclude people from doing things. They're not positive rights. So in other words, if I own the patent, it doesn't give me the right to go make the product. I still have to go and get financing. I have to set up a factory and stuff like that. Well, like about 30 years or so, these enterprising lawyers decided, they're of course enterprising lawyers, they figured out, hey, if I just buy a patent and go sue a big company, okay, I can make zillions of dollars depending on what the product is. Okay. And again, it's not a requirement that you produce the product. It is just a requirement you own the property. And so what these guys did is they found this very prolific inventor who had these patents, and they went ahead and sued these big Japanese companies. Okay, and so they did it on what's called contingency fee, which some of you might be familiar with, but this is a personal injury concept. And so what a contingency fee is, that in the US system, generally you pay lawyers as you go. So win, lose, or draw, you still have to pay your bills. Okay, or if you're my clients, you stiff me, but whatever. The point is that contingency fee does this. Okay, if we lose, you don't pay me anything. If we win, I get 30%. Okay, and so this requires a couple things. The first thing is it requires a lawyer who can sustain 4 or 5 years worth of not getting any money. Okay, because like, you know, if you don't recover, you don't get anything. Well, what it does is it gives the lawyer skin in the game. Okay, because if they make money, if you either settle the case, which most cases settle, or you win the case, okay, you get a percentage of that. All right. And so there has been basically, there was a very successful lawyer who did this in the early 90s. You know, basically, I got a picture of him because I actually was dealing with him. Everybody dealt with him in front of one of his planes. So if you don't care that people hate you and, like, you know, despise you, the way to get rich in patent law is by being contingency fee attorney and finding the magic patent and suing Apple on it, or Google, or whoever it is. Okay. And so the other thing that's happened, and so we call those companies that own those patents patent trolls. Okay. And the other interesting thing is there's been a more recent thing, which is called litigation finance. And so you have companies that are willing to invest money into patent suits to get a percentage of the profits. And so what they will do is they will go through patents and figure out these patents that somebody might be infringing, go buy the patents, and then find a law firm and then say, I will put up $5 million for your legal costs in exchange for what are the percentages. And so there's a sizable percentage of patent litigation in the United States that is what are called non-practicing entities, people who don't produce the product, or patent trolls. And that's driving litigation. There's a decent argument, well, there's a very good argument that this kind of litigation is not very helpful for developing technology. because obviously these people are in it for the money. And they're not developing technology as a byproduct of owning this patent. The only reason they're owning the patent is to try to cash in on the big corporation. And so there is a pretty good negative argument that strengthening intellectual property just increases the number of trolls. Okay. Now, there's also probably an affirmative argument that if you can figure out some way to stop the trolls, that might be a form of strengthening intellectual property protection, because it would actually have the beneficial effect of getting patents for the right reason, which is, in theory, encouraging the development of technology. But that's going to be an interesting debate, and there is a ton of literature on it, because Congress has tried numerous times to sort of curb this kind of thing. And the courts have set off rules to make it more difficult for patent trolls to file suits. So
Do you
if you
expect
want
that
to
to
get
be an
rich,
app?
I'm sorry? Yeah,
Do you expect that
probably.
to be an app?
Probably. It is arguably topical, because, like I said, I think that the essence of stopping patent trolls is actually making it harder to sue people on patents. But if you can figure out some way to do it, then you can argue that stopping the patent trolls actually increases the effectiveness of protection writ large. But those, I think that you're going to have to do some reading in terms of the issue of patent trolls. But there is a ton of literature on it.
And then you mentioned before, I guess, like all the different kinds of apps, you can just pick a different technology every tournament or something like that. But
Yeah.
what do you think will be like the biggest evolution of IP protection like in the next decade?
No clue. I think that I'm hoping that although it would gut my practice, that there is better resolution on software, because it's a critical part of it. It literally touches everything in our society right now, and given the fact that our economy is based off of information, like not having protection over, or making it hard to get protection technology on that, is difficult. It is not good. And so there has to be reform. The problem is the Supreme Court, the last time they stepped in, they made things even more confusing. The patent office and courts are fighting about it. And so Congress probably has to step in, but the problem is there's not much of a motivation in Congress to do something about it. And so we're left with a pretty chaotic system that is very problematic. That's one aspect. I mean, there's but I think that touches on a lot of things. So this patent eligibility question in terms of software is really, really a critical issue. I'm not sure we're going to see any resolution on it, which is fine.
Thankfully, we have the power of fiat.
Yeah.
And then do you think that's kind of like the fight between the patent office and the Supreme Court and like other actors over software IP? Do you think that's like the biggest legal controversy right now? Or is there some other like major disagreement between courts that's popped
between
up?
courts and the patent office, there's probably some other ones that I haven't looked at, but that's the major one right now. Is the patent office's their criteria for what is eligible is not consistent with what the court generally indicates, and at least for the federal circuit. The Supreme Court has chosen, despite being invited and at least 3 separate occasions in the last 5 years, they've declined on this issue. I mean, thanks, guys, because they created this mess in the first place by passing the Alice, by basically deciding the Alice decision in 2014. But they have basically put us into and even that's the other thing, is that you can make an argument strengthening protection is consistency. So even if you cut back the technical protection, the clarity might still make it an increase, a strengthening of protection, although and I think that gets into really shaky T ground. But I think that there is an argument that having consistent and clear rules, even if the margins they cut back, is probably better, in terms of if you're investing billions into technology, for example, you'd like to know whether you can get a patent on it. And that's a real thing for clients or technology companies.
And then another thing I kind of thought about when like thinking about what might a 1AC look like was the international aspect. I know Emory's like starter packet AI app has an advantage about like just generally regulating AI and like relations with the EU, but less about like IP. So I
Yeah,
guess if you could talk about like the international elements of IP, like treaties
sure.
between nations about IP, or like what might a relations
All
advantage look
right.
like?
So I think that there are two areas that of international treaties that are relevant. The second one I have, let me start with the first one. So there's something called the Patent Cooperation Treaty, or the PCT. And basically that is a reciprocal agreement between countries in that they will give you equal rights in terms of obtaining patents, assuming that like you're parties of the treaty. And so that doesn't mean that if I apply for a US patent, I automatically get a patent in the rest of the world. What it does mean is if I decide to apply for a patent in the rest of the world, as long as I'm applying for that patent within a year, I get credit just as if I filed in that country at the same time I filed in the United States. Okay. And so there's a concept called patent harmonization where we're trying to make the patent systems of the world relatively consistent. Okay. And so, for example, most patent systems in the world, the patent term is 20 years minus the time that it takes you to get the patent. That's been more or less uniform throughout the rest of the world. Okay. Something that the United States like threw out in terms of this patent harmonization is related to your other question, is that in most of the world, including the United States now, they work on what's called a first to file system. So the person who gets the patent is the person who goes to the patent office first and makes that patent application. The United States, up until about 1990, had a first to invent system, which is basically whoever invented it first gets the patent. So it doesn't matter when you go to the patent office. And so the problem with that system is it's really hard sometimes to figure out who invented it first. The patent office, by the way, had their own separate branch to figure this out. They called it an interference, and you would have to, well, basically put out evidence. Yeah, I was in a bar with Josh Clark, and I put it out on a napkin. See, here's this napkin, and Josh will come tell you I invented it. Well, Raleigh, like he had this like demonstration at this trade show in April, and look, it had all the stuff, and this napkin, what is this? Like, it's or some red mark, like, but no, I'll get Josh to testify that, like, and so you have these really, keep in mind, nobody would file this unless the patent was really valuable. For example, television. The television patent was in one of these disputes, I believe in the 30s or the 20s. There was a big dispute on who actually invented television. But because people even back then realized, yeah, this might be a thing. Okay. And so the first to invent system, in theory, is rewards or incentivizes people to invent more because not everybody has the money to go file patent. But administratively, it's a lot easier to do the first to file system. So that's why we moved to make it more consistent with the rest of the world. And so I think that there, from an international dimension, the United States might influence other countries in terms of protections. Their domestic patent law might have effects on other countries' abilities or other countries basically reciprocity with the United States in terms of protection. So I think that that's certainly a fruitful ground. Now, there are other nastier things we do with patents overseas. So pharmaceuticals, GMOs, and U.S. privacy standards, I think, all have implications in terms of how the United States protects it and what the impacts they have on standards. I haven't gone too much into that literature, but those are all potential things because, and that gets into the second realm of international law, which is important, which is U.S. trade law. And so basically the U.S. Trade Act was, I believe, Section 330 at SEC of the U.S. Trade Act. Well, they set up a special court called the International Trade Commission. And the International Trade Commission allows you, if you're a domestic manufacturer and you think you're getting infringed, you can go to a fast track procedure. So keep in mind, patent law or patent legal suits in regular district courts take forever because they're big cases. Under the International Trade Commission, you have 1 year to resolve it. That's a statutory requirement. So you can't screw around. But the International Trade Court, basically, you have to have somebody overseas like importing an infringing product. But the reason why that court exists is because it is part of U.S. trade law to sort of protect international industries. Well, we're also using the patent regime to, or U.S. companies are using the patent regime, which granted are international or patents in the specific country. But the reason they're doing that is because under trade agreements, they have to give reciprocity. And so if we do get the patent in there, they have to give it force in the country. And that is arguably a domestic law because of the trade law. And we're using, so for example, one of the issues in pharmaceuticals is this concept called generics. And what a generic is it's a lower priced version of the drug. It's exactly the same drug, except like they price it at probably 50 or 60 times less. Well, you know, in the United States, we can afford to pay like $1 billion for a drug, you know, because we're relatively well off and we have this thing called insurance. Okay, well, you know, those drugs in third world countries, if you sell them at the prices the United States sells them, a lot of people die. And so there is a big tension because generics will come in and sell it at a lower price. So that's one example. Another example is genetically modified organisms or seeds. Okay, so basically these are seeds that have been grown to do things like be resistant to insects, or you know they're weather resistant, or you know they grow bigger tomatoes. I don't know. Okay, but the thing about those is that if you look at they don't sell those seeds; they actually license them. Part of the license is you can't grow that seed for the purpose of growing other seeds, because obviously then ConAgra couldn't sell the next year's worth of seeds. Well, they enforce those in the third world, and for the third world, those things are really necessary to increase crop yields. And so the way they can prevent people from doing that is by having a patent over the modification on the seed. So those are two examples. There are a lot of other examples. There's a bioprospecting app we ran 20 years ago that talked a lot about how the United States is using intellectual property to appropriate cultural knowledge and biological knowledge from third world countries, for example. And so those are probably good ground for settler colonial links, for example. But yeah, there is, if you look for it, I think there is definitely an international dimension because U.S. intellectual property law has influence. And the other thing is that the U.S. is the biggest market for a lot of companies. So, yeah, just to be clear, U.S. patents only are enforceable in the United States. So if I make and use and manufacture in China, I can't, if I have a U.S. patent, I can't go, hey, Chinese factory, stop making illegal iPhones or whatever. You can't do that. The fun starts, though, because the United States is the biggest market economically. And so if you want to make money, you're going to have to sell your product in the United States at some point. At that point, once you do that, you start infringing patents. So that's why U.S. patents are valuable and have an influence even worldwide, is because people want a U.S. patent. And by the way, like you don't have to be a U.S. citizen or U.S. entity to own a U.S. patent. Okay. In fact, like for the longest time, like Japanese companies, several Japanese companies were the largest, they had the largest number of patents. And so if you are an overseas company, you can apply for a U.S. patent. And so that's you know, there's definitely a dimension there.
I think we have time for one more. Raleigh, do you mind if I take it? Okay, so I guess this is a two-part question. One is the first part is it sounds like being affirmative, there's like a very dynamic aspect where you know we're going to be able to debate about who should do it, and there's going to be a whole lot of products in order to protect with increased patents and a lot of different advantage ground, et cetera. Sounds like it's sweet to be F.
Right.
Is there negative ground? And if not, kind of where do you see the negative going to be successlet on the topic?
Yeah,
This
that's
would have been
something
my
I've been,
last question too.
yeah, this is something that I've been asking myself because let me start with the K ground first. Okay, I think that capitalism, the premise of intellectual property is a good thing. Okay, well, the premise of capitalism is, well, property is a good thing. And so there are a lot of criticisms for the patent system in terms of relying on property as a concept, because even though there are economic justifications for property saving resources, there's lots of economic reasons why property is not very good. Okay, and so a cap, I think, is huge because in order to be topical, you have a link. The second K link is probably technology. And I was surprised when the NATO topic, there was not very many tech Ks out there. But the second premise of the app, or the second premise of the resolution, is intellectual property by inference means technological development. And so there is a lot of authors that think tech is not the best thing ever. And so from a case standpoint, I think that those are sort of the starting points of your links. From a policy standpoint, yeah, that's not great. The problem is that the things that are bad for this resolution from the negative standpoint are, first of all, nobody really cares. I mean, people care, but they're very specialized people. And so as a result, nobody is going to win or lose the 2024 election on strengthening intellectual property. Trump is not going to get up there and go, Biden is senile and he's loosening intellectual property. But, when I get into office, I'm going to reform Section 101 and make it better for artificial intelligence LLMs. Trump is not going to say that. Well, first of all, he can't spell any of those words. But second of all, it's not happening. Like, no one cares. And so it's going to be really difficult to get your standard politics links or your election links because, it's going to have to be something like, oh, well, patents would have an effect on drug prices and people would sell it as pharmaceuticals. Okay, I don't think that's a great link. Okay, and that's about as good as it gets. Okay, and so politics are out. Okay, economy, maybe. Okay, because obviously if you strengthen patents, you give license for people to increase prices, that might lead to inflation. So maybe, but again, if the affirmative can get by this by basically targeting patents to certain areas of technology. And so it's just a price increase in one sector and then claim advantages. The third thing or negatives might be able to do is an agent counterplan. And I think there's going to be very vigorous debate on whether Congress is the right person to do this, whether the patent office is the right person or the right party, or the court. Okay. The problem with this is a clever affirmative. First of all, unlike yours topic, like this USFG will do whatever is probably beyond the superficial level. It's probably not going to work. Like, the good old, oh, the USFG will do this. And what branch do you use? Well, we could use any of them. Okay, because most of the solvency literature, I believe, is going to say the U.S. Patent Office should do this reform, or the court should step in and do this. Okay, and so it's going to be very difficult, although my debaters are very, very, they try hard to, down highlight so we eliminate certain things like Congress should do, whatever. So I think that a good negative, again, you need to know the roles of the branches and why it is better for one branch or the other. And then you need to have a disadvantage against the other branch. So for example, if you are going to do patent office reform, you duck out of any residual politics stuff, because what they do, nobody knows what the patent office does. And I don't even know, and I deal with them every day. And so, but the thing is that has Chevron implications. So you could make arguments that strengthening the regulatory regime is bad. Okay. Courts. The problem is the traditional courts disads don't really apply because, again, the Supreme Court just doesn't care that much about intellectual property. And I don't know if this is going to be an app or not, but there could be apps that just deal with the Federal Circuit Court of Appeals because practically they handle all the patent appeals. Okay, and so I think that having the right agency counterplan, you're going to have to be good at debating all three branches, and that might be a possible negative in. Okay, there's process counterplans, so depending on which branch they are, I'm not a fan, but that might be the way to go. Is that okay? You're doing this through rules and comments. I haven't seen a regneg link for the patent office. but that might be it, for example. So if you go through the agency, here are agency process counter plans. If you go through Congress, here's our Congress process counter plan. If you go through the courts, here's our court process counter plan. Okay, and so I think that those are possible options. Yeah. So yeah, no, it's what else is what negatives are in the Emory packet?
There's an industry diss ad that's about like AI use because the app's like AI should stop stealing other people's copyrighted material to train it. And then this ad is just like that's gonna limit AI's ability. But I mean I was
Yeah.
thinking about for like another diss ad, like a patent office trade-off diss ad. I don't know, like obviously it would come down to whether or not the app can fiat they get more resources through like strengthening protection. But like would that be viable potentially if there's the app
Possibly.
set for it?
So the way the patent office works is yes and no. I mean, I think that it would be I'm not sure there's literature on this because the patent office doesn't move around resources. How the patent office is organized is they have three main technological branches. They have electrical, chemical, and mechanical. And once a patent is filed, it's assigned to one of those branches. And then under each branch, they have a subgroup. And so eventually you filter down to the technology that you're applied. But as far as I know, they don't like if, for example, hey, there's a lot of software patents being filed in the area of search engines, and we only have 10 dudes working in that. Like, it's really hard to get, hey, the people who are dealing with buggy whip patents, those 5 dudes aren't doing anything because there hasn't been a patent filed on buggy whips for about 100 years. Like, we'll get these 5 guys over to examine search engines. Well, the problem is that practically, like, they don't have the technological background, so they're not going to be of much use. So even if it's true that they could transfer people, which I don't think they can, okay, there's a practical problem with the people in each one of these things are so specialized in terms of their knowledge of the technology. You just can't replicate these people. And so it's not as simple as, oh, the patent office will overemphasize this area. And then, first of all, I'm not sure it works that way. And second of all, even if that was true, I'm not sure that, practically, that not that there's any literature written on this. So, if you can find the evidence, you can probably still run the diss ad. But practically, that's probably what would happen with the patent office. On the other hand, they are also they were the first people to pioneer the work at home concept because when they built their new building, they already had too many employees, so they told everybody, "Hey, go work at home." And so most patent examiners actually work from home, so they're all over the place. The GAO actually, unfortunately, caught them. Because if you're really experienced, you know all the technology. So the way it works, the way you keep your job is you have a certain number of hours. And so you have a certain number of patents you have to examine every month. Well, if you've been there for 10 years, you've looked at every piece of technology. So let's say it takes 40, you get 40 hours. If you can do it in 15 hours, then you go play golf for the other 25 hours. Well, the GAO found out about this, and yeah, they they found out guys were working 20 hours and getting paid. And I mean, they're doing a good job. It's just so yeah, they put a stop to that. But there's yeah, I think from a patent office perspective, like I said, there's process, there's perhaps increasing the efficiency of the patent office. But I think, the other negative generic is simply patents don't help technology. Okay, they just don't. And so like everything else especially under this year's topic, that's actually sort of a nuanced argument. There's probably, the truth is, in certain areas of technology, patents aren't great. In other areas of technology, they are really good. Okay. Oh, by the way, I guess the other way the negative could go is they could go with some sort of pick out of certain technology or a certain type of patents. And I think that you can probably actually find literature for this. It will be hard to find a specific advocate for the specific pick, but there's certain processes where the patent office can either speed up or stop the issuance of patents. So the example of how they can stop patents is if a patent deals with certain national security things, and this doesn't happen a whole lot, but every now and then, you'll get a patent that's something that is a technology that we just don't want out there. So, for example, advanced cryptography, when public-private key came into play, I think that some of those patents were pulled back, and they were not. The government just said, no, that we're not. We'll grant you the patent, but you cannot make it public, and so it was useless. And so there are instances where the government has pulled back certain technology because it is so sensitive to national security that they're just not going to let the technology out there.
Okay. All right.
So yeah,
feel
so
like
when
we
you figure out
gotta-
what the negative could do, email me so I can tell my teams to run those things because I don't know. Like,
All right. Well, it's good that Apple have a good year, and the one thing that I'm hopefully looking forward to, it seems like the apps will be sufficiently dynamic to be able to defend their actors that it'll be a lot more difficult to read process counterplans. And if they are just agent counterplans, there seems to be ground to argue the validity of which agent to use.
I think so. Yeah, I think that there should be a decent amount of literature, comparative literature in terms of one mechanism or the other. The question is whether it rises to the level of debate level net benefits, because again, the literature in this area is relatively specialized. And what is a big deal to patent attorneys, most people fall asleep to. Like, oh yeah, they changed the software standards. I'm so excited. And everybody else is going, what, huh? So I think that it is going to be a challenge. It's going to be a challenge. This is a very highly specialized topic. And it's going to be interesting because it's you can get to levels of minutia that that I think a lot of other topics just you weren't really incentivized to do that. So we'll see.
And that concludes the first episode of Topic Knowledge. Thank you so much for speaking with us today. And thank you all for listening. Feel free to reach out to us with any questions or inquiries at policydebatecentral@gmail.com.